Yeah, we just won't say that when we see people coming into the room. We won't say their names because this video is going to be going out.
Yeah, it's recording right now, correct?
It is recording, yeah.
Okay.
I don't know if they can get in before 6:30. I think they
No,
can.
we already have some people in already.
Oh, we do, right.
Yeah. Welcome, you guys.
Yeah.
We're going to give everyone a few minutes to join us. So
Yeah, so now we've got the chat feature. I believe only you may be able to select who can see what you're writing. I know I can select the hosts and panelists or everyone or just Ashley. Also, we have a place for Q&A. If you have questions you'd like to put in there, but I don't really know how those questions work. So maybe it's better to put it in the chat.
okay. Usually the questions I think would be asked by us, those ones. So for the Q&A.
Right. So yes, we'll read the questions out. Right, is that what you're saying?
Yeah.
So we'll see the questions and we'll read them.
Yeah. So if you guys have any questions throughout the presentation, you can put them in the chat and we can discuss. We're going to do a Q&A after after the presentation. So after the discussion, I guess.
So we'll just give it another minute and then we'll get started.
Okay.
All right, we've got a few more people coming in. Hello, everyone. Good to see you. We're just going to wait another minute or two for a couple more people who are expecting to come in. All right, we'll give it about 30 more seconds and then we'll just get started. Sound okay?
That sounds good.
Oh, hello to those of you who just logged in. It's good to see you all. We're just waiting another minute for people to come in. If you have questions that you'd like us to go over at the end, there should be a Q&A button where you can submit those for us and we'll be able to see them and we'll talk about them at the end. I think we can go ahead and get started.
Okay.
If someone comes in late, they'll be able to catch up.
Okay. All right. Well, everyone, thank you so much for coming to the webinar today. This is the first webinar that we're going to be doing this year, and it is our Friends and Family Fiduciary Bootcamp webinar. And basically what we're going to be going over is the duties and responsibilities and things that our trustees, our power of attorneys, as well as our executors will need to know in order to basically fulfill the role that we have given them in our estate planning paperwork. So let's get started. Let's see here.
Okay, can you see that?
Yeah, okay. Sorry, it just popped up another thing on my screen. So sorry about that. Okay, so just to introduce myself, I haven't met all of you in person, but I have talked to most of you on the phone. I'm Ashley Klaus. I am the Client Relations Director here. And basically, my main focus is really on building and maintaining relationships with our clients. And this is even after we've finished our services and you have finished your paperwork. We always want you to feel comfortable coming to me with any questions you might have afterwards. And just to tell you a little bit about myself, I do work remotely from home, in my home in Colorado. I have 3 kids, all boys. And if you're wondering about my background here, during COVID, my boys were playing too many video games. And so a friend introduced me to some modern board games, and it's been an excellent adventure playing with my boys over the last few years. So yeah, sorry, I don't know if you were able to see that when I was showing you before. Thank you, Richard. But really, my purpose within this law firm is basically, I just want you guys to feel like this is a space where you can find answers to your questions and you can be comfortable recommending your friends and family to us. Our clients really are everything to us, and we grow by serving our clients and making them happy. So our goal is to really serve you guys, and we want to do more than just give you your documents, but actually help you face future challenges as well. So as you know, we created the Legacy Group to allow our clients the opportunity to receive ongoing communications from the firm and to have a place where our clients can continue to learn best practices and make things run smoothly for those that they will someday leave behind. So today we're going to be discussing a little bit more, going in depth on what the trustees, executors, and power of attorneys, what they need to know to be able to fulfill their roles. And at this time, I'll turn it over to Richard.
Okay, thank you. Yeah, and I just want to say also, everyone who's in this webinar is either a former client or has been invited by a former client because they were assigned to serve as executor or trustee. This is not a typical, this is not a marketing webinar. I've not opened this up to the public. I didn't blast this on LinkedIn or anything. And that's what the goal of this is really just to try to fulfill your needs, your questions. That's what this is about. This is not a sales pitch or anything. I don't have any prospective clients in here. So if you do have any questions, just let us know and we'll try to answer them. That's what we're trying to do. So I will get started. Let me share my screen. Okay, so this is the Friend and Family Fiduciary Bootcamp. There are 2 parts. I've broken this up into 2 parts. The first part is for the perfect family, where everyone gets along and everything is just fantastic and rosy. And I found some pictures of the perfect family online. And so we're going to talk about just some general rules and principles that apply to everyone, and just assume that everything is going to go smoothly. Part 2 is we're going to focus on an actual or real family, families that exist in the real world, some of the problems that they might have, and we're going to address some of the questions that they might have. I searched for a picture of an actual family. This was the closest picture I could find of a real family, of what a real family looks like. She's smiling, but you got to be careful. You don't know what's coming next. And this is what all families are like. There's always a little bit of this in every single family. No one ever, sees things exactly the same way. There's always some disagreements. So we're going to talk about that a little bit too. Before we begin, I just want to point out that everyone here, or I guess all my former clients, you are all grantors. You've set up your own trust or your testators, your own will, or principles in a power of attorney. So you've created these documents and you've named other people to serve in those positions. But we are going to discuss all of these things from the perspective of the people that you have named. So from the perspective of the trustee who's going to be taking over, or the executor who's going to have to probate your will, or the agent who's going to have to execute your wishes under the power of attorney. So we're going to talk about it all sort of from their perspective so that you can understand what they're going to have to do. And we'll talk about things that you can do that will make their jobs easier. I see in the list, some of you have invited some of your family members who you've assigned to serve in those roles. So that will be helpful for them too. And this also might be helpful for those of you who might find yourselves as executors of your parents' will or something like that. So you might find yourself in this position as well. The main takeaway is that each of these people, the executors, the trustees, the power of attorney, you are serving as fiduciaries. Fiduciary is a word that, it comes from the Latin word to trust. And that's really what this is all about. It's about serving in a position of trust, to hold something in trust, confidence, reliance, that sort of thing. So you want to choose someone, obviously, that you trust is going to make the right decisions. And also those people that you chose are going to be held to a certain standard. You're entrusting them with a significant responsibility, and the law expects them to behave in a certain way. And that is all to protect your wishes. When someone serves as power of attorney, they're not supposed to just do whatever they want. They're supposed to do what you want them to do. So here are the questions for what I call the perfect family. These are just general questions about how everything is supposed to work. What should I do first if you're serving as trustee or executor and your parents die and you've got to take this over now? What should be done first? What deadlines do you need to be aware of? Can you pass the responsibility on to someone else? If you've been named as power of attorney or executor, do you have to serve, or can you let someone else do it? So we're going to discuss some of those things. And these are just general principles that apply to everyone. Then we're going to talk a little bit about some real questions about, real life, the real world. Questions about what authority do I actually have? What can I do? What can I not do? This is where things get kind of tricky. Does everyone have to agree? If you're serving alongside someone else, you co-trustees, how does that work? What if there are disagreements? And then what if I receive pushback? I'm executor of the will and my siblings are, legatees or beneficiaries, and they don't like what I'm doing. What do I do in that case? How do I handle that? So we're going to discuss that a little bit. Just a quick recap about trusts and wills before we move on. So a trust is designed to hold property for beneficiaries. You're holding it for a period of time. And then at the end of that, you're going to have to distribute the property. A will is kind of the inverse of that. It's designed to distribute property. A will is not designed to hold property. It's really just about how to pass it out. It will have to be held for some time while you're taking care of that process. But that's kind of the difference between the two. A trust is more flexible with varying timelines and varying reporting requirements. Oftentimes it can be done without going to a court at all. It can all be done privately. But there are a few rules that you need to follow. A will is much less flexible. A will is going through probate. It can be administrative probate or judicial probate. Administrative probate means you don't have to go in front of a judge. You just file it with the Register of Wills and they give you the documents that you need and you take care of everything. It's not as flexible. There are set timelines. There are set requirements for reporting. You've got to file inventories and accounts, and the deadlines for all of those are fixed. So in many ways that makes it easier because they tell you exactly what you've got to do. For a power of attorney, just to go over this again, with the power of attorney, you are designating an agent to act on your behalf. That can be, it can become enforceable immediately or after a triggering event. You could say that when I lose capacity, then the power of attorney goes into effect. And another important point is that it automatically terminates at death. If I have power of attorney for my dad and my dad dies, I can no longer use that power of attorney to do anything. I can't use it at all. But the main point for a power of attorney is that you're standing in for someone else. You can do whatever that person could do, whatever things that the law allows them to do, you can do on their behalf. They give you permission to do that, and that's what the power of attorney is. So that's a quick recap of a trust, a will, power of attorney, and the trust is the trustee, the will is the executor, the power of attorney, the person who's acting there is the agent who's acting for the principal. All right, so we've got a perfect family. Let's say you are the executor of your parents' will or trustee of their trust, and they die. That's usually how this begins. Your parents die, and now you become trustee, or now you become the executor. So we're going to talk about sort of how you need to get started, what you need to do next. What you should do first in general, the first thing to do is locate the documents. When I was working on this PowerPoint with Ashley, she recommended that I put in this next part, which is make sure you read the documents. I wasn't sure whether to put that in, but I decided actually to put it in bold red letters. That's very important. If you don't want to read it, you're always welcome to hire me to read it, and I'll read it for you at $300 an hour. But if you want to do it yourself, I recommend you always read the documents all the way through. So you're the executor, you're the trustee, your parents have died. Locate the documents, find the will, find the trust. The other thing, next you need to find the property. Where are their investment accounts? Life insurance, IRAs, 401ks, all of those things. If they have a burial property, their cars, any property, bank accounts, you need to locate all of that and figure out where it is. And you also need to locate the beneficiaries or the legatees of the will. Make sure you are in contact with all of them, because you're going to need to communicate with them. So specifically, if you are a trustee of a trust, what should you do first? One of the things I recommend is finding a good CPA. They can help you apply for an EIN number. If you are a trustee of a trust, of a revocable trust, and the grantor dies, that trust now becomes irrevocable. It's going to need to get an EIN number, because if the trust continues to accumulate income, it's going to have to pay income tax, or at least file income tax returns, even if no taxes due. You're also going to have to prepare some reports for the beneficiary, and there's no template like you can get at the Register of Wills to do that. So I recommend finding a good CPA who can help you do those types of things. If you're the executor of a will and your parents have died, the first steps you need to do after you've located the documents and everything, you need to deliver the will to the Register of Wills. It's right down here at 50 Maryland Ave in Montgomery County, a couple of blocks away from my office. You need to take it to them and file a petition for probate. You'll need a death certificate. You'll need a copy of the will. I'm sorry, I put copy of the will. You actually need the original will, not a copy. They need the original will. If the original will is lost, you can submit a copy, but then it's a few more hurdles you have to go through with judicial probate, so that can be done. But ideally, it should be the original will. You'll need a list of all interested persons. Interested persons are heirs and legatees, so that's people who would inherit if there were no will, and if there is a will, people who are set to inherit from the will. So if I make my will and I leave everything to my children and my friend Bob, then my children are interested persons, and my friend Bob is also an interested person. If I make a will and I don't leave anything to my children, and I leave everything to my friend Bob, my children are still interested persons, because they would inherit if I hadn't done that will, leaving everything to Bob. So they need to be notified of everything. You need to give that list to the Register of Wills. You'll also need a rough estimate of the value of all the property. It doesn't need to be exact, it's just a guess. The main point of that is that you need to know whether it's over $50,000 or under $50,000. That's the main point, because that will determine which kind of probate proceeding you'll be able to open up. Am I making sense, Ashley?
Yes. Yes.
Okay.
You are.
All
Well,
right.
I think you are anyway.
Okay. All right. Now let's talk about so that's kind of how to get started. If you're trustee, I recommend read the document, hire a CPA, prepare to file reports, not file reports, but to give reports to the beneficiaries. If you've got a will, you've got to take it to the Register of Wills. You've got to start that probate process. Let's talk about deadlines now. If you're the trustee, you need to notify beneficiaries within 60 days of that trust becoming irrevocable. So I have a trustee that has hired me now. His father left a trust to his sons and also 10 other charities. We had to send out letters to all of the charities within 60 days to notify them of the existence of the trust and to tell them that they're allowed to request a copy of the trust document. You also have other deadlines that those are going to be in the trust document. When this child reaches a certain age, you distribute the money, that sort of thing. If you're the executor, the deadlines that you have, you're supposed to initiate probate quickly. There's not really a penalty for not initiating it, but you're supposed to do it as quickly as you can. After you do that, 3 months later, you need to file an inventory, which is the list of all the assets. So you need to gather that information and submit that. Then at 9 months after filing for probate, you need to file an account, which is an account of where everything is gone, or where everything is going, distributions that are going to be made. If you're not able to distribute all the property within the first 9 months, then you need to continue to file an account every 6 months until that's done.
Sorry,
Yeah.
Richard, real quick. So the inventory is everything that is in the estate, correct?
Right, all of the assets.
And the account is where everything is going to be going?
That's right.
Okay.
Yeah, thank you. Once you file the final account and everything's been distributed, then the estate is closed. And then you're done. And there's nothing more to do. With a trustee, there's no, with the will, once you've distributed everything, you file the final account with the Register of Wills. It gets approved by the judge, and the judge signs an order closing the estate. With the trust, once everything is distributed, there's nothing left in the trust and there's nothing left for you to do. So that's how to get started, and that's essentially how to stop, how to close everything out. Let's talk about this question. Can I pass it on, meaning the responsibility, can I pass it on to someone else if I've been chosen as executor, trustee, or power of attorney and I don't want to do it? Can I let someone else do it? And how does that work? So this applies to all three of those. You can always refuse to accept. So just because someone named you as trustee or power of attorney or executor does not mean that you have to serve. You can refuse, and you can always refuse. You never have to do something like this if you don't want to. What if you've accepted it and you don't want to do it anymore? It's gotten too difficult, or for whatever reason, you want to stop doing it. Can you resign? Yeah, you can always resign. You can always stop. You just have to make sure that you do so in a way that you properly discharge your duties. There may be things that you need to do. You need to notify certain people. You can't just walk away. That would be an issue. You'd have to make sure the correct people are notified and the correct process is in place for things to be taken care of. You definitely can't just walk away and pretend like nothing ever happened. You've got to make sure it's all set up. But you can always resign as long as you do it properly. Can you pass it on to someone else? Meaning, can you choose someone? I don't want to do it, but I'd like my brother to do it. Can you do that? Sometimes you can do that with a trust. A trust can give you the power to appoint a successor trustee. Usually not a will. I've never seen that in a will. I'm not sure you can do that in a will. So we don't do that in wills, and you can't do that with a power of attorney. The principal themselves needs to make that decision. It's not for you to pass on. Okay, are there any questions about that?
Richard, we did get one question. How detailed does the inventory have to be? Does it have to be like every book and every DVD, or is it more broad?
Yeah, that's a really good question. So there's actually a form that the Register of Wills has that will show you. You will need to get, if you've got DVDs and books, you get a personal property appraisal. We just did one. It only cost $325. We had an appraiser come and just look at everything. And they only pick out the things that have market value that could actually be sold on eBay. And they assign a value to that. And so you take that and you put it right back. You stick that in with the inventory. Things like real estate, you just use the tax assessed value, and then brokerage accounts and bank accounts. That's simply you include a statement of the bank accounts. So it does need to be reasonably detailed, but no, you don't list every single book. You just leave that up to the appraiser to do that, and they'll list out whatever they think is valuable, and you just include that. And then on the front page of the inventory, the form that the Register of Wills gives you, you just write down the total amount of all that personal property. I hope that answered your question.
Thank you.
Does that make sense, Ashley?
Yeah, it does. Is it common to get an appraiser?
Yes. Yeah. You do have to have the property appraised.
Okay.
So part two, we're going to talk now. That's all general rules, how everything works. when everything is going smoothly. We're going to talk a little bit now about real families. Again, I Googled real family dynamics, and this is the picture that came up. This is the most accurate picture of how real families work. Let's talk about this. There's always disagreements. I've been named as power of attorney, or I'm executor. What authority do I have? What can I do? What can I not do? This is something that's important to understand. Okay, so I see a question.
That just popped up. Yeah.
Right. So if a spouse dies and most or all property is held in common, how does the inventory apply? So if that's the case, for joint property, you don't have to probate the estate. It just skips probate altogether because it goes directly to the other spouse. So there's no need to probate it, and there's no need to file an inventory. Okay, so what authority do I have? What can I do? What can I not do? Let's talk about a trustee. You're a trustee of your parents' trust. You have the authority to hold property for someone else, to invest property. You have a fair amount of discretion. You are holding the property as if you are the owner. So you essentially get to decide what to do with that property, with a few restrictions we'll talk about. The executor, what authority do you have? You do not have a lot of authority, or a lot of discretion, I should say, as the executor. Your job is just to hand out property to other people. You don't get a lot of choice, or a lot of say, or a lot of control in the matter. You distribute it according to what the will says and what the laws say. What can you not do as the trustee? You can't invest the money recklessly. There's a prudent investor, or a prudent actor, basically, standard. You must be prudent in the way that you safeguard and invest property. You cannot just take all the money for yourself. You're holding that money for other people, unless the trust says that you can take it, then you can. But if the trust says that you're holding it for other people, which is what generally all trusts say, you can't take the money for yourself. If you're the executor, what can you not do? You can't choose who gets what. You can't cause delay. Again, your hands are kind of tied. You've got to do, what you've got to do. You don't get to make a lot of choices. If you're an agent under the power of attorney, what authority do you have? You can do anything that the principal would be able to do legally, and anything that the principal allows you to do. So when they sign a power of attorney, you can sign a general power of attorney, which gives someone authority to do everything, or you can sign a limited power of attorney, which only gives them authority to do certain things. But with power of attorney, I mean, there's an enormous amount of discretion. This is the one where you really get to do all sorts of things as power of attorney, because someone can give you authority to do anything. When you do a general power of attorney, you're giving that other person the authority to do, anything. So it's a lot of discretion, a lot of choices to be made, a lot of difficult choices, because the person is still alive that you're making these decisions for. So we'll talk about that. Can you make gifts? You sometimes can even make gifts. The power of attorney can allow you to make gifts even to yourself. So there's quite a bit that can be done with the power of attorney. But a big caution about a power of attorney. Power of attorney can be revoked. Just because you have power of attorney doesn't mean you get to do whatever you want. Even though you do have a lot of discretion, you're supposed to do what the principal wanted you to do. If the principal still has capacity, they can revoke it at any time. You cannot tell the principal what to do. If my dad gives me power of attorney, that does not mean that I get to turn around and tell my dad what to do. My dad is still the boss. Another thing is, other people do not have to listen to you just because you have power of attorney. If I go to the bank with the power of attorney, and this is a nuanced discussion, but you say, I've got power of attorney, I want to take all the money out. Well, the bank might say no, right? Because we don't know if this power of attorney is valid or whatever. And we'll get into, that's a little bit more of a nuanced discussion, what to do if that happens, if the bank isn't listening to you. You can go and get a court order to force the bank to do what you want, but you need to be prepared that some people just might not accept that power of attorney. I think we've gone a little long, so I'm going to speed up a little bit. Do co-trustees have to agree? If I'm trustee with my brother, we're co-trustees, and we disagree, what do we do? Co-trustees or co-executors can be given authority to act either individually or by joint decision. That's something that you put into the document. If you say that they can act individually, then they can act individually. If you say by joint decision, then they both have to agree. So that can be a little bit difficult. What if I receive pushback? What if I'm serving as executor or trustee and my brother doesn't like what I'm doing? This is something that I try to convey to my clients. It is better to receive than to give. What I mean by that is, I see this woman here who's receiving the packages from the delivery man. The delivery man is the fiduciary. He's holding the packages, but he's giving them to the woman. I'd rather be the woman than the guy. I'd rather be receiving stuff than have to go out and deliver things. So being a fiduciary oftentimes is a thankless job. It's a lot of work, and you don't necessarily get any more money just because you're the one doing all the work. So it's not a fun thing to do. I'm the executor of my parents' will, and I kind of wish I wasn't. I mean, it makes sense. I do this for a living, but it's not fun. I'd rather someone else do it. But I will do it if my parents ask me to. That's a responsibility I'm willing to take on. And if people are not happy with what you're doing, I would just say my big takeaway is that remember that your job is to follow instructions as trustee, as executor. You follow the law, follow the rules, follow what the documents say, and don't worry about what other people say. It's not up to you to make decisions about who gets what. That's in the documents. You're just there to follow instructions. And people are going to be upset, and it's not your fault. If I've executing my dad's will and my brother doesn't like what's in that will, I'm sorry, it's not my will. I didn't make the rules. I'm just following the rules. So I just have a couple of quick examples and then we'll wrap it up. So question 1, I'm agent under the power of attorney for my father. I think that my father should move into a nursing home, but he doesn't want to go. Can I make my dad go into a nursing home? I sort of touched on this. The answer is no. Just because you have power of attorney doesn't mean that you can now make that person do whatever you'd like. They can revoke that power of attorney and they can make their own decisions. So if they no longer have the ability to make decisions and they signed a durable power of attorney, then yes, you may be able to do that. But that's a tall standard to say that they don't have the ability to make decisions anymore. And there are cases where someone has power of attorney for their dad, and they want their dad to go into a nursing home, and their dad doesn't want to, and their dad, can take legal action against someone trying to use a power of attorney to do that. So, no, just because you have power of attorney does not mean that you're the boss. Question number 2: my mom died and left me trustee of the trust. My brother did not help with her care and did not even attend the funeral. Can I withhold his portion of the trust? The answer, of course, is no. You must follow the instructions in the document. This can be difficult. I know you see that as trustee, you want to do the right thing sometimes. Maybe you think your brother's not going to spend that money wisely. I'm sorry, you've got to do what the document says. It's not the trustee's job to decide how to distribute the money. It's the grantor's job. When you make the trust, you make that decision. Last question. My parents died and left me personal representative. Their will leaves everything to me and nothing to my brother. Can my brother sue me? No. Again, your brother cannot sue you. You've not done anything wrong. You did not write the will. The only thing your brother can do is to challenge the validity of the will itself. And that is a problem. That can be an issue. But again, that's not against you. You didn't do anything. And as long as the will was done properly with witnesses and there was no undue influence or anything, then the will is going to stand. And, your brother's just going to have to, he's just going to have to deal with it. It happens, every day. So final recap, what should we do now that we understand a little bit what these people are going to have to do in our life? We should choose the correct people to serve, someone that we trust. Tell them where your documents are. Tell them where you keep them. Tell them what property you have. Try to make a list of the accounts, and it doesn't have to be incredibly detailed. But if you say I've got a bank, money at Bank of America, and I've got some money invested with Fidelity, let them know that. And then you're always welcome to give them my contact information and have them call me if they have any questions. So that's it. That's all I have. It was about an hour, went a little bit longer than I wanted to, but please feel free to reach out to me or Ashley if you have any questions. And Ashley, do you think there's anything else, or should we just end it?
No, I think that's everything. Yeah, if you guys in rewatching the replay or if you come up with any questions you have like later on, you can always email me and I can either reach out to Richard or be able to answer your questions. We can always get back to you. So yeah, if something you think is something that you weren't able to think of tonight, just send me an email.
Yeah, and it was so good to see so many of you show up tonight. It's nice to know. We didn't know if this was going to be interesting to people, so it's nice to know that this was a topic that people were interested in. Again, we've got the recording that I think you all should have access to if you need it. Any other questions, don't hesitate to reach out to me or to Ashley. Thank you, Ashley, for everything you're doing with this group, getting it all, just taking care of all these clients. I want everybody to know, this is part of the reason why I brought Ashley on. I've got to be working all the time, and I just have to do new wills all the time, and I don't always get to take time out to take care of my former clients who did their wills a while ago. But these people are incredibly important to us. These are the ones who tell their friends about us. I mean, this is important. We've got these documents out there. I want to make sure that people know how to use them, and so that their family knows how to use them, and they know how to get the best value out of what we've done. So it was great to see all. Well, I didn't see you, but I see your names here in the list. It's great to see all of you. And Ashley, good to see you too. And I will talk to you later.
Okay. All right. Goodbye. Good night, everyone.
Good night.